Welcome, Economic Justice Law Review. We're doing a special video. I'm Andre Smith, your host. I'm the Executive Director of the Economic Justice Law Review. We're doing a special video on the Byron Allen case, Comcast versus the National Association of African American Owned Media. As many people know, that case was decided by the Supreme Court last Monday, a week ago today. And so we've had a chance to digest the actual judicial opinion authored by Justice Gorsuch and signed on as a unanimous opinion with a concurrence by Ruth Bader Ginsburg. And so we're going to break it down jurisprudentially, basically analyzing the text, the intent, the purpose, and the modern dynamics related to that case, or at least how the court sees it, and then, of course, my criticisms. Now, we're going to try to do it, cut it short. I mean, the very first attempt for me to write up the case, I wrote 20 pages on it. I mean, it's that much to talk about, so we're not going to spend that much time. We're going to try to cut this off for about a half an hour or so. But I definitely want to give you the essence of the opinion, its implications, and jurisprudentially how they got there through the text, through the intent, through the purpose, through the modern dynamics. Those are the four pillars of statutory interpretation in my book. Text, intent, that represents form. Purpose, and modern dynamics, that represents consequences or reality. So formalism versus reality. Now, I am a critical theorist, so let's start with the premise that no one particular answer is commanded by logic or God or what have you, that each justice or the judges are trying to make the decision that, as Ronald Dworkin would say in Law's Empire, the decision that fits. And they want to show that it fits through the opinion and its consistency with legal and social principles. The four major legal social principles are text, intent, purpose, and modern dynamics. But this case is showing, actually shows that how much modern dynamics are practically verboten, so we can reduce it to three, right? Modern dynamics is also called judicial activism or policy arguments. But the interesting thing is that purpose was disavowed. The only justice to make a reference to purpose was Justice Ginsburg, and no other justice signed on to her opinion. And so her concern for the statutory purpose of the law stood alone and practically ignored, which portends very badly for race relations or the interpretation of racial statutes. Civil rights statutes in the future. Another interesting jurisprudential dynamic that we notice is that she is also the only person to cite legislative history, old school traditional legislative history. And so for her to leave the court soon, where it would appear, and this is just this case, so we would have to do a broader evaluation of the court's language in other cases. But if we were just to hyper focus on this particular case, it's hyper focus, or it's exclusive attention on the text as intent, and then the court's own interpretations as kind of the agents or the work for hire of the legislature as intent, is problematic when we also disavow the purpose. Right? So this excessive commitment to formality is beyond the immediate implications of this case when it comes to race. However, it is portends very badly. It is a very bad omen for the future of civil rights cases if we're going to disrespect the purpose. And especially if we talk about the interpretation of other general statutes and whether those interpretations that debilitate or exacerbate racism and racial subordination, if they're not under consideration, if it's only about the form of the statute through an analysis of text, and we'll show you how that that analysis is still ambiguous It's still vague. Does not produce a single solitary concrete answer, despite the fact that the case is unanimous. But again, the long-term effect of this jurisprudential cabining into formalism is, to me, almost as troubling as the immediate consequences of the decision, which is to raise the barrier for civil rights cases dealing with contracting. Right? So that's the intro. That's the intro. So when it comes to its implications, let me be frank. I'm going to read this. This is kind of my bottom line to it. I guess I could have said this at the end, but let me state it frontwards. As far as how it affects me personally, and especially when it comes to this political season of 2020 coming up. And so I basically say that the realistic black agenda, right? There's a lot of talk about what is the black agenda. All right, as much as it ought to include reparations and what have you and other types of things, that's a broader agenda. If we're talking about for 2020 and the presidential election and what we expect these parties to actually do, I say that the realistic black agenda, as I see it, must include a public commitment to nominating Kimberly Crenshaw to the Supreme Court after Sonia Sotomayor, Alina Kagan, and Stephen Breyer all failed to stand up for racial justice in the Supreme Court's unanimous decision against Byron Allen. After each of them signed on to an exceedingly formalistic majority opinion and failed to explain in their own words why the debilitating and widening racial wealth gap is not worth the judiciary's time and attention. And after they each failed to even sign on to Ruth Bader Ginsburg's attempt to limit the damage done to the oldest civil rights law in the books and give Allen a morsel of a chance on remand, leaving her, him, and it swinging in the wind. The only way I can possibly imagine getting enthused to vote for Joe Biden is if he commits to Kimberly Crenshaw for the Supreme Court and to Elizabeth Warren as vice president so she can implement the widest possible student loan cancellation program feasible, the benefits of which disproportionately inure to black people in America, the ones who took the bait and followed the rules by actively pursuing economic and social inclusion through education. And that's just assuming that raw economic justice is enough. And if you need some type of deservedness, how about the black folks that actually were sold the American dream, spent thousands of dollars on education, and didn't get the yield that it produces. So to me, this case certifies or concretizes what I would like the black agenda to be, and that is, again, a Kimberly Crenshaw, and I speak of her specifically because we know that judicial opinions are writing contests, and if the court is going to cabin itself into formalism, we need more or less, and again, I'm a hip-hop guy, so we need one of the wickedest MCs ever, right? Somebody who is absolutely wicked with the pen and able, from a critical or even purposive or realistic stance, be able to address and attack rampant hyper-formalism, right? Hyper-formalism sounds very attractive, and it is not easy to defeat, but it can and it should. And I would hope that or I would suggest that a mind as deep as Kimberly Crenshaw's is what we need on the Supreme Court to do battle with the Samuel Alitos, with the Gorsuch's, Kavanaugh's, Roberts, etc. I know that people say President Barack Obama, and there's other names. I personally like Sherilyn Ifill for Supreme Court, but far from being aside from being someone whose heart is in the right place, again, these are MC battles. They are written battles, rhyme battles, and what have you. And so we need someone that is absolutely phenomenal when it comes to written argumentation, especially from a critical perspective. And I believe that is Kimberly Crenshaw, right? All right, so that is the implications, or that's where the case brings me. But how did we get there, right? What about the case angers me so to say that I need the black agenda to be such? Well, first of all, let me say that the case purports to be statutory interpretation when it's not, right? that's a controversial claim for me to make, but the court states from the outset that instead of interpreting the statute to determine what the legislature of 1866 meant, what they were aiming for, what was the plain meaning of the words at that time, the question the court asks is that they have their own jurisprudential rule that they will only use a but-for standard unless they find evidence to move them to do something else, right? That is not interpreting, right? That is using some of the tools of statutory interpretation to accomplish the goal you set out for yourself, whether you're moved off of your default rule. But the default rule was not a product of the legislature's intent, and neither is the attempt to move you off of the rule. The jurisprudential rule that they're speaking of, that they would use a but for instance in almost every case of private right emanating from a federal statute, was not crafted till the late 20th centuries, the 80s, the 90s, and what have you. So to ask whether the legislature of 1866 intended to counter this Supreme Court's default rule, that's not interpreting. That's not interpreting. That's not trying to figure out what is in the mind of 1866. That is trying to see if there are reasons to move you off of your rule that you implemented by yourself and have your own standard that's fairly unspoken as to when you will accept something from your rule. And what's most disappointing, again, from Kagan, Sotomayor, and Breyer is that we do have the opportunity to counter that default rule. The court even notes that, yes, a default rule admits of exceptions. And so for Sonia Sotomayor, Kagan, and Breyer, and Ginsburg, she signed on to the majority opinion, for them to feel as though racial subordination, right, that is so anti-meritocratic, anti-democratic, especially in the era of Citizens United, or maybe because of Citizens United, that they couldn't make the case for an exception is very, very, very disheartening, especially when the textual analysis, to me, is pretty darn weak. And honestly, I really would have felt maybe a little better if they would have each written their own concurrent opinions that did invoke the purpose and all that, even to say that they would join the majority in result, to say that we're going to maintain that rule and that race relations don't necessarily, or racial subordination doesn't necessarily alter the default rule. But I would love to hear it from their words. Right? Why were those purposes not enough? What other purposes, what other consequences are more important? Judicial economy, judicial restraint, the smoothness of the law, the notice to the citizenry. What is it about this default rule that is so important? That what are the good things that come from it? What are the great consequences that the default rule produces that an exception would destroy? That wasn't discussed. Wasn't discussed at all. And so I would have loved to have at least a concurrence from Breyer, Kagan, and Ginsburg, Sotomayor, describing why the balancing of those interests, those consequences, fell on the formal side rather than the justice side. I would also say, before we get to the actual text and all that other stuff, that from a critical perspective, from a racial realist perspective, well, I guess this case was going to happen, right? That interest convergence theory predicts this, or Derek Bell's interest convergence theory predicts this, or as I should say, interest divergence predicts this. So again, for those that are watching it, you're probably familiar with Derek Bell's theory of interest convergence, that the civil rights laws are enacted and interpreted positively towards the eradication of racial discrimination only when it also serves the interests of elite whites. So when we talk about Brown versus Board of Education, we're dealing with an era where America had to disavow its apartheid because the rest of the world got hit, right? That the communist Russia and others were using American apartheid to our disadvantage, and therefore we had to at least front like black people were included. Same civil rights laws that in the 60s, the Civil Rights Act initially broadened the employment base, the labor base, right? So on the one hand, while it may piss off racist white folks or non-elite white folks because of the greater labor competition, for the shareholder class, it is more productive, right? The labor competition is more intense, and there is more cream to rise to the top and pluck in a fairer and more meritocratic market. But here, right, that's Section 1983 and all that about, but here when we talk about contracting, right, we're talking about people in the capital class. And so treating black people or erasing racism when it comes to contracting, right, having a higher standard that black contractors are to be treated, quote unquote, as white citizens, which Section 1981 requires, that case was not going to come in our favor because it is against the interests of capital class whites or elite whites, right? So we were able to more or less predict the outcome of this case to begin with. It would have been nice to be wrong when it comes to interest convergence and divergence every so often, but it seems to be a very, very powerful tool, theory towards explaining the past and predicting the future, right? That's how we evaluate theories. Its capacity to explain the past, but also predict the future. Because of this interest divergence, again, this is because there are so many instances, including this one, where the interests of blacks and elite whites diverge, and where we cannot then assume a political solution, then that gap has to be filled by, as Albert Einstein would have said when he was invited to write an article in W.E.B. Du Bois's Crisis magazine, that closer union amongst the minority is necessary so that the soul of the minority should be emancipated. So for those, so for my progressive-minded folks, I love you, but at the same time, a panoramic or well-rounded strategy for black elevation and elimination of racism includes a black nationalist perspective and program to deal with the issues where the interests of blacks and elite whites diverge, and there can be no realistic expectation for a political solution or a political solution by itself. That is also exacerbated by, again, the presence of Citizens United, the case, which basically says any political solution has to have money behind it, because if money is speech, then as Citizens United certifies, then if you ain't got dough, you're not saying nothing. All right. Again, when we talk with the implications, the further implications, one of the why practically this particular issue with 1981, what is so bad about it? All right, let's talk about that. By ruling that there has to be a but-for causation to win under Section 1981, and also just to get your case in the door, right? They made this perfectly clear that you have to prove that you would have gotten the contract, that Byron Allen had to prove that he would have got the contract with Comcast, but for his race. He has to show that race was not a factor, but the factor that prevented him from getting the contract. It's as if And that's a very high evidentiary burden to prove, right? Especially when he says, his claim clearly says that they are going to use pretext, that white folks are smart enough not to say, oh, I don't like this person or I don't want them because they're black. They're going to make up reasons. And the court said nothing about his proof or the pretextual nature of the reasons. They just said that there's Comcast said it, and then we're going to believe it. But here's the thing. Right, trading places. Eddie Murphy as Billy Ray Valentine is hiding in a bathroom stall when he catches the Duke brothers, Randolph and Mortimer, when he catches them saying that they would never let a nigger run their company, and therefore they're going to get rid of Billy Ray Valentine. He had to hide in a bathroom stall to get that type of evidence. This is the type of evidence the Supreme Court says we need to prove racial discrimination in contracting, rather than finding that there was a motivating factor and finding that they had racial animus more generally in this particular situation. And that even goes towards the pleadings. You would think Byron Allen's argument was, well, at least if I can show you that race is a motivating factor, race is a factor within their decision-making process, that should let me in the door to get to what? Discovery. So that discovery can then find the actual proof of the inner conversations, the inner emails and whatnot that show that they were not just being racist generally, but specific to Byron Allen. So the court even rejected that as a fallback, that even if you have the but-for standard at the end for the jury, that we should have a motivating factors test at the pleadings. And the court totally rejected that. Right? They totally rejected that. They basically are taking the position as backed up by the U.S. Chamber of Commerce and the Trump administration that black folks are just playing the race card. Right? That we use the race card to get undeserved privileges within this economy, when all of the statistics and the numbers show that we are woefully underrepresented in almost every commercial context. But the court is very concerned with the expense accounts or the expense statements of major corporations, and that they have to spend too much money fighting so-called frivolous lawsuits. Even though, in this particular case, black folks that contracted with Comcast, that actually even have contracts with Comcast, will tell you that they are not about inclusion. They are not about any type of racial fairness or what have you. So here's an exercise. And here's the question of the day as far as the implications of this case. Because a but-for standard is required, you must satisfy a but-for standard rather than a motivating factor standard. Here's my question and my concern. What if a contractor asks for bids from subcontractors, and to evaluate those bids has a grid, right? Has a grid, and he's going to assign points to the categories in this grid for education, for former clientele, for price, for quality, and then also for race, right? That they have a certain amount of points that they're going to give for being white, black, Asian, whatever the case may be. This person is a racist, right? This person should be outed, right? If this were in Section 1983 for employment, case is over. Right? We believe that the purpose of the Civil Rights Act, at least when it comes to Section 1983, is to out these races from our national economy. But apparently, if you can get away with it, it's cool in Section 1981, right? So if you have this grid and you give demerits for race, I have proven that that race was a motivating factor, but I have not proven that I would have won the bid but for my race, right? I haven't proven that. I haven't shown that my application was objectively far better than all the other applicants. And what if it's not objectively far better? What if all the applicants are more or less the same? It's cool. It's fine. Be racist. Exclude black people. have demerits for black people and race or whatever, because if it doesn't, if black people, it's not that if it doesn't matter, if black people can't prove that it absolutely mattered, then you get away with it. You're fine. You're fine. So the court for the last 40 or 50 years has, at least, even if they don't deal with pretext or whatnot, they had been fairly good at sanctioning overt, blatant racism. But it seems we're taking a turn here. And this is not coincidental. We have the Federalist Society and neocons all over the place arguing ever since Bob Jones versus U.S. that the First Amendment protects their ability to be racist, that freedom of religion protects their ability to be racist. And even the U.S. Chamber of Commerce included that in their briefs. Right? In their amicus brief to the court, the U.S. Chamber of Commerce sat there and talked about not only the expense that their companies have to spend defending against racial Section 1981 racial exclusion cases, as if they shouldn't. On top of that, they're also going to invoke the fact that even if the evidence that Byron Allen presented was true, that there were people that just don't like black people up in there and part of the contract, well, then that's just part of free speech, right? Corporations have free speech. I can say what I want. I can be racist if I want to. So for the court to start entertaining that in the 21st century, and for all four liberal justices to sign on this opinion, is absolutely, it's not just troubling, it's frightening. It's frightening. The racial wealth gap. What if there's an auction? How about this? We're in coronavirus time. What if there's an auction and there's one roll of toilet paper left? Right, one roll of toilet paper left, and the store owner, who has said all types of racist stuff before, and that doesn't matter, it's not relevant apparently because it's a motivating factor, it doesn't show but for. But let's say this store owner with the one roll of toilet paper says, I'm gonna auction this off, but none of you darkies need to bid because you're not gonna get it. Well, I still haven't. I've proved that. Again, the Supreme Court is there, I have proved that race was a motivating factor. But I have not proven that I would have won the auction but for the racism. Right? I have to prove that I would have outbid. What if someone else had more money than me? What if someone else can prove that they had a greater need than me, supposedly? How do I then turn around and prove conclusively that I was going to win that bid? Out of all of the bidders, I was going to win that bid, right? Number one, that means only one black person has standing, right? And that black person has to be the richest person in town, if not the country, in order to have standing, because then someone else can always say, well, I would have outbid you, right? There's no proof that you would have gotten this but for your race, because you were not the richest man in town. You were not the richest person in the auction. And even if you were, there were other people that wanted it more than you. Prove otherwise. It's on you. It's on you, the plaintiff. Prove otherwise. That's what the Supreme Court has set up. So you either got to be Billy Ray Valentine hanging in a bathroom stall. And let me go back to that. The Dukes are going to deny that they said it. So he's going to have it recorded. Right? Then they're going to say they were playing. The hurdles that are set up. So the idea that we are going to use these laws to push towards a post-racial society is kaput, right? If that was the purpose, to eliminate inefficient, racist, immoral, unjust competitors from our national marketplace, this Supreme Court has failed. Now, if the purpose was to maintain racist, unfair, anti-meritocratic, inefficient businesses and put a drag on this country, so long as you don't overtly exclude a particular black person, and we will only vindicate that right, well, then that's what we have from this particular case. Now, the thing about the auction, Ruth Bader Ginsburg's concurrence at least tries to preserve the court's ability or the statute's ability to sanction that that exclusion from the auction, that the actual bidding process is a right, or arguably a right, in the making of contracts, and that it was denied. That right to actually bid at all was a right that was denied because or on account of race, right? And I was not treated as a white citizen in that respect. The court said, well, we'll wait till we see that case before we deal with it. So that'll be interesting. Byron Allen can try to squeeze his case into that by saying he had a right to negotiate as a white citizen. But again, I'm not sure if the court is going to go for that. So grids, and what if that auction just ignores the black people there, right? In the example that I gave, they just said, we're not going to accept any bids from you darkies, right? Well, what if they don't say that? Because again, people are smart enough. People are smart enough to avoid saying that stuff, and they just avoid. They just, I didn't see any of the black bids. I didn't see any of their bids. The lights were out. It was too dark, right? They can, again, the Byron Allen case says now they can use pretext. As long as they have some pretextual reason to exclude black people, then you can't prove that you were excluded, that you would have gotten the contract but for your race, or you would have gotten the bid but for your race. They're going to say that you did, but for whatever reason, it wasn't recognized. They said they didn't see you, so they didn't see you. Too bad, so sad. Whew. All right, so Section 1981 requires plaintiffs to prove race was a motivating factor, or to prove that the contract would have been acquired but for race. I'm going to deal with the textual arguments real quick. First of all, again, when we deal with this grid, I'm gonna keep beating this grid to death, because if you put me in a grid and you give me demerits from my race, I don't believe I should have to show that I would have gotten the contract but for my race. I feel like I should win right there, because the statute, the text of the statute, says that I'm supposed to have the right to enjoy contracting, to make right and make and enforce contracts as white citizens. Giving me a demerit for my race in your grid, you have not treated me as white citizens. There's no way. Just out of the plain text of the situation, it does not require the but for. The interesting thing about Gorsuch's analysis of the statute is he's using all these words. It says on because of, on account of, and he says, well, yeah, those things seem to invoke the but-for standard. That the but-for standard is used in almost all tort actions, right? You can't win unless you prove that your injury was caused by that conduct, right? That there was a specific injury and that it was caused by that conduct. But again, the question becomes, if I haven't been, if you use this grid, I haven't been treated as white citizens. But here's the thing. It does include, those statements obviously do include a but-for situation. If I dissed you straight up because of your race, if I didn't give you the contract because of your race, obviously it fits into words like because of, on account of, and things of that nature. But that's not the question. We know it's inside of that. The question is, why isn't motivating factors also within that plain meaning? Right? That's never discussed. It's only discussed that but for is included, and nobody argues that it's not. There's no argument but for is included. It's within the circle of motivating factors. So Byron Allen, nobody argues that but for causation shouldn't be sanctioned. Everybody says it's obviously within the statute. The question is, why isn't the motivating factors test within the plain language, if that's what you're truly asking? right, is in the plain language of this, is a black person who gets demerits for their race, have they been treated as a white citizen? No. The person who has been denied the contract strictly, directly because of their race hasn't been treated as a white citizen, and neither has the person who got demerits for their race. Neither one. Right? Neither one. They compare it to Section 1982. Right? They compare it to Sections 1983. They argue that the motivating factors test in the Title VII, Section 1983, in the employment context, that it can't be carried over. Number one, it's written expressly in Section 1983. Now that's important. That is a very strong hook that they have incorporated. That these two statutes are very close to each other. The motivating factors test is written expressly in Section 1983, but it is not listed in Section 1981. I promise you, if the decision would have focused almost exclusively on that and been much shorter, I probably would have accepted it a little better. The going around the mulberry bush about how all these other factors support the but-for test, when it, in my view, it just doesn't, really makes the court look bad, and it really makes Kagan, Sotomayor, Breyer, and Ginsburg look bad to sign on to it. We've passed 30 minutes, so I don't want to spend too much time further, but the court, I want to talk about, again, the fact that the court ignored, number one, the legislative history of the case of the 1866 Congress. So we're talking about statutory interpretation, but there are no references in this case about what was on the minds of the legislature in Congress in 1866 and how broadly they wanted this case to be the statute to be interpreted. As a matter of fact, Justice Ginsburg is the only person who at least recites cases talking about Section 1981 was designed to eradicate blatant deprivations of civil rights, such as where a private officer refused to extend to an American because he is an African American the same opportunity to enter contracts as he extends to white citizens. But Ginsburg says it also is a sweeping law designed to break down all discrimination between black men and white men regarding basic civil rights. Right? This comes from Jones versus Mayer, their 1968 case. Right? So she is the only one that actually takes purpose seriously, and even when she does, she doesn't use the congressional work papers of 1866. Right? We don't talk about that particular Congress. Now she gives very good information about the how the court has cabined Section 1981 in the past, only to be rebuked by Congress at least once or twice before. Right? She also talks about the 2008 case, where the decision is broader than just the actual contract formation, that it includes enforcement, and that it also includes the negotiating process. So we'll see if that comes back. But what's also interesting there is she cites House Report number 102-40, that this was to bar all racial discrimination in contracts, and that this list is intended to be illustrative and not exhaustive. Again, her recitation to legislative history used to be regular, right? It used to be a normal thing that we would teach as far as how to get to the legislature's intent. But here we have only Justice Ginsburg doing so, and I hope and pray that the reason why Kagan, Sotomayor, Breyer, and did not sign on to her opinion is because of they're turning their back on purpose, because they're turning their back on legislative history. Those tools are very important towards expanding the law expanding the breadth of written statutes to include the combating of racial discrimination, racial subordination, etc. So we're going to stop there, right? We can go into much further detail, but for that, I'd like you to read the text of the essay that we're going to write towards this. I'm also going to include a chapter on this on my upcoming book, Afro-Atlantic and Jurisprudence, so we can talk about text, intent, purpose, and modern dynamics in action. This is a perfect example of how we can critique the Supreme Court jurisprudence using those 4 techniques. So law students, regardless if you like the opinion, the outcome of the opinion, we're going to use this as a tool of how to and how not to perform statutory interpretation. It should be a very good lesson for those of us that are interested in lawyering for civil rights, especially for those that are on the appellate side, and also for those of us on the administrative side. When you deal with government bureaucracy, when we're talking about the arbitrary and capricious test, we need to have the tools of statutory interpretation to argue that interpretations or legal rules that promote the racial wealth gap, that promote racism and subordination, right, are outside of the legislature's intent. Now, outside of the legislature's intent and purposes, that it is poor statutory interpretation not to consider and recognize those dynamics. So we're going to stop here. It's been almost 45 minutes. And again, I thank you for stopping in for this is the Economic Justice Law Review. I am your host, Executive Director Andre L. Smith, and we will see you later for our weekly scholarship review every Wednesday. We're going to take the latest in scholarship on race relationships and describe them in an economic matter through my concept of racially asymmetric market imperfections and failures. I'll shoot other videos explaining that in more detail, but thank you for joining in today on this discussion of the Byron Allen case. Thank you.